Okay.
that we have a trial conflict.
Okay. Let me ask, I guess, a little bit about that. Is it something that has a decent potential of not going in terms of your conflict, Mr. Ham? So my thought would be this, is to schedule you all for that date and give you a backup and hold that date for you all here on the 20th. And let's say, you know, November, December, your conflict resolves, then we can go ahead and go on the 20th, but then give you all a backup date so that if that remains a true conflict, then we already have you all set. That makes sense.
That makes sense, Judge. Just looking at this one, it's my only concern is that this case does, as it's said, or as it stands right now, it does look like this one has a pretty good potential to go to trial. I actually have there's a lot of motions going back and forth, and we're a good distance apart. I mean, these cases sometimes do settle as well, but I guess, you know, I would just put that out there that I do think it's a good chance it will go, but you know, we can.
Sure. You know, and I'm not going to hold you to it. I'm not going to say, well, you were set on the 20th. I've got it. You have a conflict right now, but in the event that it were to resolve, we would have a, you know, status in early December to check in with you. And if at that point we knew, you know, we really weren't going, then we could go forward to the following date. I just, because especially in early 2023, our trial settings are pretty much full. The fact that I have this one here kind of makes me want to give it to you no matter what. And then if you all can't use it because of conflicts, then we can go to a backup date. I don't know if that, yeah, we're going to do that. So, but I hear you, Mr. Ham. I know you all, I understand you have a conflict as of right now. As we get closer, if that happens to go away, that'd be really good. So we're going to do January 20th with a January 18th docket call. There will be a final civil pretrial 30 days before that. We'll actually schedule it. I don't want to get too close to the holiday. We'll do it on December 7th at 10 a.m. And that will more than likely than not be the date that I recheck and see if we still have conflicts. And then Myrna, do we have a subsequent date?
Looks like April, Judge. April 7th, Judge.
Okay. Can you all check your calendars on that one? Because if everybody's good with that one, I am going to specially set you that date.
April 7th works for me, Judge.
That works for my clients as well, Your Honor.
The plaintiff is fine on that day, Your Honor.
Yay. Okay. So special set, Myrna, for April 7th, but we will try and squeeze in that 120. If it doesn't work, we just cancel those days and move on to the April date, okay?
Yes, ma'am.
All righty. Anything else on this one? If you need a hearing on anything, let us know. Send us an email with your pleading and we'll get something scheduled, okay?
And
Thank you, Judge.
Just to confirm, Your Honor, the parties are allowed to enter into a scheduling order, essentially renewing all deadlines.
Correct. I guess we didn't send that out last time because we didn't have our trial date, right? So yes, new scheduling order. And let's use that 120 date as our timetable.
Yes, Your
Okay.
Honor. Thank you.
All right. Thank you very much. Appreciate your help on this one. I know it was kind of weird. Thank you.
Thank you.
Thank you, Judge.
Thank you, Your Honor.
Y'all are excused. Who's next?
In cause number 2022 DCV 0298, Mario O'Kelly Castro et al. Versus Gloria Perez. Announcement of council, please.
Good morning, Your Honor. Jesse Herrera for the plaintiffs.
Bear with me. I was not hearing. Good morning, Mr. Herrera.
Good morning.
1 second. 0298. Okay, so wow, well, this is our first status conference. This has been filed since January. What's the status here, Mr. Herrera?
Your Honor, briefly, we've settled the two adult cases already. We're waiting for an offer on the minor. We have an issue with Medicaid, and once we figure that out, then we'll get that thing settled.
Okay, we'll set it for a status in 30 days.
Okay, Your Honor.
Do we need an ad litem?
I'm not sure yet, Your Honor. If you want to appoint one.
I'm gonna appoint, well, just because I'm looking at her right now, I'm gonna appoint Ms. Mendez.
Okay.
Good morning.
Judge.
Good morning.
Good morning, Judge. I welcome the
So-
appointment. Thank you.
Oh, we'll send you the order shortly. So we'll come back in 30 days and go from there.
Thank you, Your Honor. May I be excused?
Thank you, Ms. Mendez. Thank you, Mr. Herrera.
Thank you, Judge.
All right, who's next?
Top of page 2, Judge.
Mhm.
In cause number 2022, DCV 0355, LVNV Funding LLC versus Raul de la Torre. Announcement of council, please.
Robert McLaughlin for the plaintiff, Your Honor.
Good morning. We're set for a status conference, Mr. McLaughlin. Can you give the court an update?
Your Honor, we're still working on service.
Well, if you need some relief from the court, please let us know sooner than later. I'll reset you for a status in 30 days.
Thank you, Your Honor.
Yes, sir. Who's next?
Maybe-
Thank you. You may.
Bottom of page 2, Judge.
I believe we received the scheduling order, if that's on 2221, but I don't know if there were any other outstanding matters.
Ms. Rubio is here for, on that cost number, Judge.
Ms. Rubio, you're here for Mr. Avila, right? He had a hearing in California? Am I remembering correctly? I can't hear you.
Sorry. Can
Oh, there
hear
you go.
me
Okay. Yeah, and so I don't think there was anything else. I do not see Ms. Marquez here. I did sign off on the scheduling order, if I'm not mistaken. So we should be good to go. Do they have future settings? 2221? With the scheduling order, we should.
Also, Your Honor, I wanted to add that we did go ahead and serve the defendant, Ms. Jasmine Moore. She was served on the 19th.
I did read that. I think they had a good locate on her. So we have future settings. We'll see you. Wow. We don't have anything else until June. All right. I'm going to leave the settings as is. Thank you, Ms. Rubio.
Thank you.
Okay, who's next?
We have incomplete parties, Judge.
Did we get the scheduling order back on Camila Burton on the first page?
Yes, ma'am, we did.
Okay, so page 1 is done. 2. Okay, well, we can take a quick break if we need to check on who's here. I see Ms. McLaughlin. 0523, is anyone else here on Eric Lujan? No, okay, so.
I am, Your Honor, for
Oh,
plaintiff.
well, here we
Sorry.
go. Okay, so 2022 DCV 0523, Eric Lujan versus Flora Corral and Victor Corral. May I have announcements, please?
Alexander Kerr for plaintiff, Eric Lujan.
Good morning, Judge Christina McLaughlin for Mr. and Mrs. Corral.
Good morning. Scheduling status conference. Are y'all ready for a trial date in August of 2023?
That sounds fine with me, Your Honor.
That works, Your Honor.
Okay, beautiful. Do you all know what mediator you're going to use?
Not at this moment, Your Honor.
Well, Your Honor, I have, and sorry, Mr. Kerr, but I have mediation scheduled for October 19 with John Rubin.
That sounds perfect for me.
Okay.
Okay, sounds like you all agreed to someone. So that's good. We'll get you your scheduling order. Please return it signed, and if you will make a notation regarding the mediator within the 2 weeks setting, then I won't see you then, and we'll just see you at a subsequent setting unless you all resolve it. And then we won't see you all on that again. All right.
Thank you,
Thank you
Judge.
very much. So did we say August 4th? Yes, August
Yes.
4th. Okay, thank you guys. Y'all are excused unless you have
Thank
something
you.
else. Who's
No, that's
next?
it. Thank you, Judge.
Take care.
Top of page 4, Judge.
Mhm.
In cause number 2021 DCV 2416, Wells Fargo Bank NA et al. Versus Leah K. Greenwood. Announcement of council, please.
Good morning, Your Honor. Travis Gray for the plaintiff.
Okay, anyone here on behalf of Leah Greenwood or Leah Greenwood? No one. Okay, so this was set for DWAP. This is the second time it's set for DWAP.
Yes, and I've been in communication. Miss Greenwood's working today, but she's been working really well with trying to get some mortgage assistance and benefits that she's hopefully going to receive very shortly and get this loan reinstated. So I told her that we would just ask to keep this case in the docket for maybe another 30, 60 days, and hopefully we can get her to where she needs to be in terms of her mortgage assistance and get the loan reinstated, and then we'll just dismiss this.
Okay, so a 60-day reset. Thank you very much. It'll be a status conference.
Thank you, Your Honor. May be excused.
You may. Who's next?
Staying on page 3, Judge.
Mhm.
In cause number 2022 DCV 0304, Wells Fargo Bank NA versus OK Dury. Announcement of council, please.
Bet that's Mr. Gutierrez. Mr.
Yes.
Gutierrez, are you there? 030.
Yes, good morning, Your Honor. I left my jacket in the far part of the office.
Okay. So that we're here on Wells Fargo Bank v. Drury default hearing. So you know what I'm going to ask, right? Did we provide notice of the hearing to party Drury? Even
Yes, Your Honor. I looked up the tracking in the Postal Service website, and it looks like the notice for the delivery was left on the defendant's residence on the 8th of this month.
Okay.
It was mailed out on the 29th of last month, and the defendant never picked up the package, but he was left notice that there was a certified mail.
Absolutely. You may proceed.
All right, may it please the court, Your Honor, we're asking for damages in the amount of $6,731.04, plus court costs, attorney's fees of $800 and contingent appellate fees and applicable post-judgment interest. We're asking the court to take judicial notice of the entire file before it. Therein, the court would see that this is a Bank of America, Wells Fargo account ending in 3900 that started off in July of 2003. We're asking the court to enter into evidence Exhibit 1, which is a business records affidavit from Mr. Dennis. Therein, Mr. Dennis attests to the account, the delinquency of the account, and ground for the redress that we're seeking. Subsection.
Sorry, sir, would you slow down, maybe a little bit more clear for me? It's kind of going.
The mic's kind of far away from me. So Exhibit 1 is Mr. Dennis's affidavit, a business records affidavit. Subsection A of Exhibit 1 would be a copy of the contract. Subsection B would be the last payment statement on the account from August of 2019. And subsection C would be the charge-off statement showing the balance that we are seeking. The petition was filed in January of this year. The defendant was served in February via personal service. The motion for default was filed back in June of this year. Notice of hearing was sent out to the defendant in the last month. And we are also asking the court enter into evidence Exhibit number 2, which is the attorney's fees affidavit from Mr. Whitney Abbott. There, Mr. Abbott details various services and such that to provide for the grounds for the $800 that we're seeking in attorney's fees. We also have a certificate of last known address for the court's consideration and related SACRA and non-active duty military status affidavit. And so the contingent appellate fees that we are seeking is $3,000 should go to the Court of Appeals and $3,000 should go to the Texas Supreme Court, Your Honor.
Okay, did you provide the proposed order,
Yes,
Mr.
Your Honor.
Gutierrez? Okay, Myrna, if you have that handy, if not, Mr. Gutierrez, it's just sometimes easier because I know this was reset once before. So go ahead and email it now. The court will take judicial notice of the entire file and admit all the exhibits and grant the default. So easiest way, Mr. Gutierrez, is to send over. Oh, okay, looks like she just sent it to me. So we'll get that file today. Thank you very much, Mr. Gutierrez.
I appreciate the court's time, Your Honor. Thank you.
Thank you. All righty. Thank you, Myrna. I think I see our motion to dismiss here.
Yes, Judge.
So let me make sure we don't have anybody else that, let's take care of Mr. Beal's case first, and then we'll go from to the motion to dismiss. And maybe, I don't know, Ms. Mendez, who are you here on? 3692.
Yes, that is the default judgment with the county attorneys on the other side.
Oh, okay.
Unless I.
And I don't
have
see them. Okay, yeah, that's at 10:30 as well. Okay, if you'll just bear with us, Ms. Mendez, we may have to take a minute, okay, before we get to your case. All right. Okay, Mr. Beal, let's take care of his case.
In cause number 2020 DCV 4192, Victor M. Reyes versus Leona Cervantes and Gabriela Cervantes. Announcement of council, please.
Mr. Beal, are you there? No. Answering. Okay, well, I tried to knock that one out before we got to our motion to dismiss. It's not going to happen, so we'll just come back to him. All right. We'll come back to that one. Let's go ahead and go to our motion to dismiss.
In cause number 2020 DCV 2345, David Jones versus El Paso Cowboy Construction LLC et al. Announcement of council, please.
Robert Riojas on behalf of the plaintiff, David Jones.
Harold Davis on behalf of the defendants, PC Builders, Mr. Kumar Del Sol Hotel, and Sidya Capital LLC.
And Albert Beal here for Robert Roberto Martinez. I'm sorry, I had technical difficulties.
Okay, well, you had to be here anyway, so we'll get you on the other side of this case. All right, good morning, gentlemen. Is that everybody? Yes. Okay, so we were scheduled this morning for a motion to dismiss. Let me just pull that back up. Odyssey is very slow. Okay, Mr. Davis, you may proceed on your motion to dismiss.
Yes, Your Honor. Before we do that, a housekeeping matter. Back in June, when we originally had these hearings set, you had Judge Reyes, I think it was, handle your docket. She granted an agreed motion to continue, but but it kind of fell through the cracks, and we've never gotten a new trial date or an assigned order.
Okay, let me go back. Correct, I don't see. So there was a motion for continuance granted. If anyone had a proposed order that hasn't been signed, if you will send it over, and then had you all agreed to a new trial track?
We had not, Your Honor. At that point in time, Judge Reyes was kind of just doing what she had to do that day, and she did a very nice job, and we appreciate it. I'm looking at late April, early May, if that works for other counsel.
That'd be fine with me, Your Honor. Anytime after March or April would be okay with me.
So Myrna, will you look at May dates?
Yes, ma'am.
Okay, so we'll get on that. While we're waiting on that, though, we can go ahead and go on the motion to dismiss.
Yes, Your Honor. Harold Davis. We filed motions to dismiss on behalf of 4 different defendants. Quick background facts are as follows. PC Builders LLC is a general contractor for the construction of a hotel in the Northeast El Paso. It hired Mr. Beal's client, Cowboy Construction, as a subcontractor, and there's a subcontract agreement in the file, as well as the original contract between Del Sol and PC Builders. Cowboy Construction hired the plaintiff, Mr. Jones, to work for a short period of time. His allegation is that he stepped into a hole that was in the floor while doing some of the work and injured himself. And he sued his employer, Cowboy Construction, its owner, Robert Martinez, and then my clients. I want to work through the motions to dismiss because they're a little different for each of the entities. So in the fourth amended petition, the plaintiff alleges that Del Sol Hotel LLC and Sidya Capital were the entities that hired PC Builders and Mr. Kumar, who is the owner of PC Builders. And that is absolutely correct as to Del Sol. Sidya Capital is, as reflected in the motion, is only the entity that financed the construction. And our position with regards to the motion to Rule 91 motion to dismiss as to those entities is that the causes of action are negligent hiring, doesn't say of who, and the failure to make sure that Cowboy Construction operated safely. Okay. So as to Sidya and Del Sol, there's a specific statute that says, this is 95.003 of the Civil Practice and Remedies Code, and it's cited in the motion, that a property owner is not liable for personal injury, death, or property damage to a contractor, subcontractor, or employee of a contractor or subcontractor who works on the real estate, unless the property owner exercises or retains control over the manner in which the work is performed, and the property owner had actual knowledge of the danger or condition resulting in the injury or death. And that's not alleged in any of the pleadings, and it's not a fact that the owner in this case was involved in the construction whatsoever. It contracted with PC Builders. So the statute makes it clear that they can only be, and there's a new case came out last year, Energen Resources, I think I cited it. That's it. No, Energen's new. That says owner can only be held liable if he exercises control over the manner in which the work was performed and had actual knowledge. And there's no pleading to that effect with regards to these two defendants. In the Endeavor Energy case, the 2019 Texas Supreme Court case, which is in the motion, it says that the protection from liability also applies to negligent hiring claims. Because in a negligent hiring claim, you still have to control the manner and method of work and have knowledge, and that's not pled. And we'd ask that these two defendants be dismissed. And I'll let Mr. Riojas respond to this, and then we'll go to the other little more complicated ones if we could.
Okay, Mr. Riojas.
First, as to Syed, I'll advise the court, we're not going to oppose that motion. I understand and I accept Mr. Davis's contention that Syed was merely provided financing for the construction of the hotel, so we're not going to oppose their motion. As to Del Sol, what I understand, and if I may just back up just a moment, Your Honor, just by way of background, this accident happened at the Holiday Inn that was being built there off of Patriot Freeway in Northeast El Paso. And we filed this suit initially against Mr. Jones's employer, and since learned over the many months or so that this case has been pending that there were some other various construction tasks that they were assigned or not assigned. What I'm attempting to explain to the court is that we're still conducting discovery as to exactly what the owners did, who they hired, who they didn't hire, what contractors were assigned to what task. As recently as yesterday, I received some documents from Mr. Davis, which contains more information about who the contractors were, the actual subcontractor agreements, the tasks that they were asked to do. There were some additional documents that he provided to me about 2.5 weeks or so ago, and I just have not been able to review all of them. So for the record, we're not opposing the motion by SIAD simply because, as again, I accept Mr. Davis's word that they financed the project, and I don't think they had any involvement in the construction, and I'll concede that. But as to Del Sol, who apparently is the owner of the hotel, we're still conducting discovery as to their involvement, as to who all they hired, as to what tasks were assigned to what subcontractors. So I would simply submit that as to our cause of action against Del Sol, it's premature. I think respectfully, we're entitled to conduct some discovery as to all of these who's and where's and so forth. And as I said, it was just yesterday, midday, that I received not hundreds of pages, but dozens of pages of various contracts and subcontractor agreements as to what all of these various entities were doing at the construction site. I will tell the court that, as you can see from the exhibits that I've attached to my response to their motion to dismiss, my client, Mr. Jones, fell through a hole on the second floor of the hotel while it was being constructed. And as I indicated in my response motion, there are very, very specific and detailed and all-encompassing rules, including OSHA rules mandating safe work areas. And those rules, as I cite and discuss a bit exhaustively in my response, those rules apply to any person or employer who they define to mean the owners of the property. There's an exhaustive list of safety rules and regulations that must be complied with, at least pursuant to the OSHA rules, whenever employees are working at heights. For example, there has to be a detailed safety program. There has to be safety equipment. There has to be inspections done as to the work areas. And those are not solely the responsibility of Mr. Jones's employer. Those extend to the general contractors and arguably even to the owners of the property themselves. There's some additional arguments I can make to the court. I don't know if Your Honor wants those discussed at present or until we talk to or talked about the motion to dismiss the general contractors. But as I said in my motion, and I'll just also point out to the court that there's appears to be some conflicting evidence about whose responsibility it was to do the flooring, whose responsibility or who was responsible for leaving that hole exposed. But I would just say in summary that as to Del Sol, it's a bit premature. I just received some of their discovery responses yesterday. I haven't had a chance to go through them all. Surely the court can revisit this at a later motion or in a summary judgment hearing. But at this early part of the discovery, I think it's premature to dismiss Del Sol.
Okay, that's a good breaking point. And so just for my purposes of keeping things a little bit organized with respect to the motion to dismiss, is it Sadia Capital?
Yes, Your Honor.
That will be granted. So Mr. Davis, if you probably have already provided a proposed order, if you would shoot that over via email as well, we can take care of that.
I will, Your Honor. In response to the argument, the documents that have been provided to plaintiff's counsel recently were the PC Builders safety sign-in sheets.
Okay.
Far earlier, in fact, in the response that I filed back in July, the plaintiff has the contract between Del Sol and PC Builders and the contract between PC Builders and Cowboy Construction. Whether there is some confusion as to what PC Builders told Cowboy Construction to do, that has nothing to do with the owner. Similarly, the OSHA issues have nothing to do with the owner. They're entirely irrelevant as to the owner because the Texas statute says, unless you can plead that the owner knew of the dangerous condition and made decisions with regards to the manner of the construction, you lose. They haven't pled that. Under Rule 91, I had a short period, the fourth amendment petition was filed in April. I filed this motion in May. We usually set it in June, like the statute requires. Now we're August. The statute says in Rule 91, I can act based on pleadings. I can say we're done and get out. They haven't pled anything against the owner that it actually knew or that it actually did something other than hire PC builders, which the Supreme Court has said is not a cause of action. This case has been pending since 2020.
So let me stop right there, Mr. Davis. So Mr. Riojas, I mean, your response to that is that we still need a little more discovery on that?
I believe so, Your Honor. If you can tell from the docket sheet, and I'm not certainly trying to deflect blame or point fingers, but you can tell from the docket sheet that there was a motion to compel that we filed against the original plaintiff, Cowboys Construction, and Mr. Martinez. There had been, from my standpoint, an unreasonable and significant delay in their returning to me any information about even who hired them. And it took the motion to compel on my part to even get from Mr. Beal's client a statement or a correct identity of who hired him. I took his deposition. Time flies, it seems, but I think it was probably a year or so ago, and he couldn't tell me who even hired him in this project. So I understand, the case has been sitting for some time, but with respect to these defendants that Mr. Davis represents, it really hasn't been that long. With leave of court, we need to amend to include more allegations against Del Sol. I think my petition refers to all defendants generally. I don't think the motion to dismiss is the proper vehicle. Maybe if there's a special exceptions that the court wants to hear, we can amend our petition and more clearly articulate or identify the allegations against Del Sol, but I don't think a motion to dismiss is a proper vehicle at this stage of the case.
All right, Mr. Davis. I don't know if you want to respond to that and move on or just move on.
Well, I just said, just go back to this. Well, first of all, they deposed Mr. Martinez in May of 21, and he asked him, who employed you? And he tells them PCS Builders. So I knew in May of 2021, that's who it was. Now, was that sufficient information? I don't know, but Cowboy Construction told them that, provided him with that information at that time. All I can say is the statute says what it says. You got to have some proof. They don't have any pleadings that my client actually did anything, and this client should get out.
Understood.
The next one would be Sam Kumar, Your Honor. He is the owner of PC Builders. And again, you got the same issue there. You don't have the statute, but you get the same issue that there's no allegation that Mr. Kumar individually knew anything, participated. Their only allegation is that maybe the charter had been forfeited for PC Builders. In my reply, I point out that's not the case, that there was a period of time that it was forfeited, but it wasn't when this injury occurred. So again, with Mr. Kumar individually, my position is you got to plead that he directed the work and knew of the dangerous condition, and they don't have that pleading, Your Honor.
Mr. Riojas, is there anything outside of is there a different response on this one?
No, Your Honor. Mr. Martinez consistently identified who he calls as Sam, as the person that hired him, as the person who directed him. Sam, as we subsequently learned many months, is the defendant. I hope I don't mispronounce his name, but Shatarati Suresh Kumar is the so-called Sam individual. I again at this, I'm hesitant to say early stage of the case because it has been pending for some time, but at this early stage of the discovery and reviewing the documents, I hate to say that I'm inclined to agree with Mr. Davis, but if Mr. Kumar was acting in his capacity as the owner or the directing member of PC Builders, then I'm not going to hold him individually liable. I think PC Builders, by all accounts, was his company. He was the sole owner or shareholder potentially. But if he was acting under the umbrella of PC Builders, then I'm not going to hold him individually liable. But I would just like to have some discovery and have his deposition done to see exactly what context and what supervisory roles he was playing in the construction.
Okay. All right. Mr. Davis?
I have nothing further, Your Honor.
Okay. I do have a few questions, but I think I primarily want to review some of the replies that I have here. And so what I mean to tell you with that is I am going to withhold, but for the motion as to Sadia Capital.
Yes, ma'am.
That one, of course, will be granted. We have a setting, and I know we were talking about scheduling. Let me go back again. Odyssey's just a little bit slow. I have dates for if we're going to reschedule this, mostly all of May. So I'm looking at either May 5th, May 12th, or May 19th.
May 5th would work for, yeah, Your Honor, Harold Davis, May 5th is best. I got an arbitration trial starting on the 15th of May.
Okay.
I'll take 10 days.
Cinco de Mayo, that would.
Cinco de Mayo.
That sounds like fun.
Give me a reason to drink afterwards. I don't need much reason, but.
Let's shoot for May.
That's
5th.
fine with me, Your Honor.
Okay. So in terms of the scheduling, but for that 9/21 setting that we have down as a final status conference, that is going to be my marker. Anyways, my deadline on the motions to dismiss is going to be September 21st. So I'm going to keep that as a status conference. But then the remaining settings will be canceled and reset per our new scheduling order with that May 5th trial setting. So.
Your Honor.
Yes, sir.
Just thank you.
Oh, okay. So we'll see you on September 21st. If I don't already have rulings on those.
Yeah.
Okay.
Okay, Your Honor. Take
Thank
care.
you, Your Honor.
Appreciate your time.
Thank you for your time. Thank you very much.
Okay.
Mr. Beal, we're going to go back
Thank
to
you,
your
Ms.
other
Biggs.
case right now. Take care, guys.
Thank you, Judge.
So let me find it. Mr. Meadowfoot, do you know which one it is? I'm lost here.
Page
Victor
3,
Reyes.
top of page 3.
Top of page 3. Why didn't I see it? Oh, because I had already checked it off. Sorry. All right, let's go.
In cause number 2020, DCV 4192, Victor M. Reyes versus Leona Cervantes and Gabriela Cervantes. Announcement of council, please.
Albert here for Victor, Albert Beal for Victor Reyes, the plaintiff.
Thank you, Mr. Beal. This was one where I believe you subbed in back at the end of July. And I think where we had left off was with some type of proposed order, and the court really, I just wanted to get an update from you. If you've reviewed it, I believe there had been a request to appoint some type of attorney ad litem. Would you please give me?
This is a partition suit. And I have a drafted order requesting appointment of commissioners to subdivide the property. We're talking about a duplex, Judge, and I'd like to save some costs here. I mean, the assumption is that it can be divided in partitioned in kind. I need to get with the city engineer to see if that's really a possibility. And after consultation with the city, see if we can legally partition this property. The judgment's ready to go if we have to appoint commissioners, but I think we may be able to get just some help from the city attorney to divide it up.
I'm very flexible time-wise. What kind of time do you think you need to look into it?
Give me about 45 days, 45,
Sure.
60 days.
I'll do 60. So we're looking at August, September, October. How about November 2nd?
Looks good to me.
Okay. Thank you for your assistance, Mr. Beal. We'll come back on November 2nd for a status conference. If you have something sooner than that, let us know and we can possibly schedule you sooner.
All right. Thank you, Judge.
Take care. Who's next?
Bottom
I
of
think we
page,
have, yeah. Mhm.
bottom
ahead.
of page 5, Judge.
Mhm. Go ahead.
In cause number 2021, DCV 3692, the state of Texas et al. Versus Ming Juan Zhang et al. Announcement of council, please.
Monty Vice on behalf of the state of Texas.
Morning, Judge Jessica Mendes. At line, I'm appointed by the court to represent Ms. Zhang.
Okay, 3692. Give me. Good morning, ladies. Appreciate your patience.
Good morning.
Okay. Weren't we coming back on the violation? Let me see. Notice of contempt. There we go. And then I feel like we still had a default outstanding, but my head's a little full right now. So Ms. Monsivais, help me, please.
Your Honor, we agreed on the terms of the default. I'm sorry, I'm getting a message that my internet connection is unstable and I've been kicked off. So just FYI. And so I don't know if you're comfortable with signing that now. I have notes and a timeline, but I cannot get back onto my computer right now. Everything crashed for me. But
so let me stop you right there. Is this the one that Ms. Mendez had last reviewed? And are we at a place now, Ms. Mendez, where do you have any other concerns or?
Sorry, Your Honor, my air conditioner just turned on. I'm trying to turn it off, so I apologize. No, I did review it. The county attorney did, assistant county attorney did send it to me, and I have no objections with the wording.
Okay, Ms. Monsivais, I frankly do not recall if I already had that in my email queue. If you would indulge me with a re-email of that default, just so it's fresh in my email list, and that will be great. That will be
okay.
great.
Thank you.
Thank you. And then now the notice of contempt. I only have it down for default, but I felt like I said today was also going to be the hearing on the contempt matter. So Ms. Monsivais, you may proceed.
Your Honor, I don't know if Mr. Carmona is here or if because you had wanted him here and I'd sent him the motion. I think that he's got some other things and I told him I was fine with the continuance if that's okay with the court.
Yeah, that's fine by me.
Okay.
Let's move it to, let's see, I think we need to go 3 weeks out at this point. So I'm saying September 14th.
Okay.
We'll send out notice and that's on the contempt matter. If there are any issues with scheduling, I'll just hear from the attorneys on that and we're flexible with dates, okay?
Okay, Judge, thank you so much.
Ms. Mendez.
I do have an observation, and I noticed that the order regarding my fees, Judge, I know we had submitted a letter with my fees, so not quite sure if that needs to be a separate order.
So I would say a separate order, and frankly, just off of memory, Ms. Mendez, I got to think that one is not complete anymore, right? Because when I received it, I feel like we were 2 or 3 hearings back. So let's just start anew, and if you will send me, if you want to send the letter, and then there will be an order with the corresponding amount on there. Okay.
Thank you so
much.
because
I think we're at least 2 or 3 hearings since the last time you sent me that. All right. Yes, ma'am. What else?
Follow from the state, Judge.
Thank you very much, ladies. Appreciate your time.
Thank you, Judge.
Thank you. May I be excused?
You may. Thank you, Ms. Mendez.
Have a good day.
You too. I see who's next.
Middle of page 4, Judge, the second one. In cause number 2022, DCV 0479, Maria Barraza versus Samuel Guerrero. Announcement of council, please.
Angela Tavares for John Carlos Serna for the plaintiff Maria Barraza.
Joshua Murphy on behalf of defendant Guerrero, Judge.
Okay, this is a simple scheduling status conference. I am forgetting, were we in April or were we in August, Myrna, on the regular newly set cases? Are y'all ready for a trial date? I didn't ask.
Judge, I'm filling in for John Carlos Serna. I know he said that defense hasn't sent out discovery, but I guess we just sent out discovery. I don't know his trial availability, but I think maybe like around May or June.
Yeah, I don't really want to set, let's see, we got an answer back in July. So I'd say a year out from July. I'm going to go ahead and set that. We're going to do July 14th. Actually, we're going to do July 21st. Sorry about that. With a docket call on the 19th. If you all please agree to a mediator, include that with your scheduling order and return it back to the court, then we won't have to see you in 2 weeks. If there's something that sticks out to you, Ms. Tavares, in terms of a conflict, generally they're so far out that, we usually catch you all before you have too much on your calendar. But if there is, I can look at another July or maybe early August. Okay?
Okay, thank you.
Any other questions? Murphy, anything? No?
Nothing further, Judge. Thank you.
Thank you for your time. Take care. Okay, Mr. McLean, who are you here on? Oh, I see. State Farm. Let's call that one.
In cause number 2022, DCP 0312, State Farm Mutual Automobile Insurance Company versus Special Recovery Team et al. Announcement of council, please.
Mike McLean for the plaintiff, State Farm, Your Honor.
Good morning, sir. We're here for a status conference.
Yeah, I have not gotten service on any of the defendants. The case is, this is a towing company that recovered a stolen vehicle that State Farm had paid for. There were issues about whether or not they gave proper notice to State Farm that they had recovered the vehicle. And then I had been trying to work to get the vehicle back and pay them for their storage when the owner died of COVID. And that's the special recovery team. Then the other defendant, Erica Diaz Soto, we think is his wife or somehow, but also work there. And then the other gentleman, Omar Diaz, he's listed as one of the licensees in conjunction with the business. Then after the owner passed, they left the house literally that they were renting, where they were conducting the business from, where vehicles may have been stored, and they're not there anymore. And we've been trying to track down the widow. And we actually spoke with her daughter, who gave us her number. We contacted them. Then I heard, and now I'm drawing a blank, I heard from an attorney who had may or may not have been representing them. And then he's never, and he let me know that he had been contacted by the lady. Then my attempts to either learn whether he is or isn't representing them have gone without a response. So I guess what I would ask for is a little bit more time to see if we can actually track these people down.
Sure.
If not, we may just be filing a non-suit.
Okay, so I'll go 60 days. Sounds like a mess.
That would be fine with me, Your Honor.
So let's do 60 days. So that's August. We'll go to end of September, end of October, November 2nd at 10:30.
Thank you, Your Honor.
Thank you. Take care.
You too.
Who's next? Anyone? Mr. Marquez. When I first saw that, Mr. Marcus, I thought it was, let's see, let me not guess which Mr. Marcus it is.
Oh, I think you're guessing right.
Oh, it's the same Marcus. Okay, good. Okay. Let's
I know
talk.
you don't see me on a lot of these types.
I don't. Mm-mm. Okay. I was thrown off. And actually, I was getting you confused when I was thinking. I was getting you confused with a Spencer, I think. Okay. So let's go on this one. Sorry.
In cause number 2022 DCV 0314, Ramon Carrion versus Juan Fenwalls Elite German Shepherds and Cindy Hernandez Jimenez. Now's been a council, please.
Good morning, Your Honor. This is Daniel Marcus on behalf of plaintiff, and Mr. Carrion is present in the office. He is.
Oh, in your office. Got you. Okay. Yes, sir. So we are reset. Good morning, Mr. Carrion. We were reset from July 13 for a default. So that kind of tells me, Mr. Marcus, that we were probably just waiting on some form of notice regarding the default hearing. Is that right?
I don't believe so, Your Honor. When we were back with on the last default hearing, we made the record on that. And I believe the direction from the court at that time was to have a transcript of that made up. That transcript should have been prepared for you to review to see if it supported the default judgment. And we were just waiting to hear back on the court's decision.
Well, hold on a second. Erica, did you send me a transcript on this?
No, I did not, Your Honor.
Okay. That doesn't ring a bell at all. Let me see.
It was when Judge Reyes was covering for you.
Okay. Yeah.
We did a whole default hearing. We presented testimony from Mr. Carrion. We presented testimony from myself on attorney's fees, and she.
Oh, I see. So she probably asked for the record so then I could go back and review it and rule on it.
Exactly.
Okay.
Yes, Your Honor.
And Erica, you did not receive a request. You did not receive instruction to prepare that record?
You know, it was on the record, Your Honor. I believe it was on the record and I just didn't like put it in. Just didn't do it.
Okay, so my
It's okay.
apologies.
There's no rush. There's no rush on time on our end, Your Honor.
So I'm gonna set this for, I don't want to set it for the default hearing again. I'm gonna set it 30 days out. This is quickly easy to fix. So
Yes, sure.
I don't anticipate it will be more than 30 days. It's just a matter of me going back. I did not review that, but I do have the motion. And so I'm not sure, I want to make sure I look at your client's testimony. Let me just look again at the motion. Okay, and I recall kind of, because there were some issues with service. I recall some of the specifics up to a certain point. Let me just double check on your motion. Okay, so the hearing that Judge Reyes presided over included some of the information regarding damages, special and compensatory, economic. That's what I would imagine is the primary. Okay, but I do need to look at it, Mr. Marcus. My apologies, Mr. Carrion. It is not something that's going to take a ton of time, but I do need to look at it. So I will reset this for 30 days for entry of judgment on the default, just so I know it's not just another default hearing. Okay?
Yes, Your Honor.
Thank you very much. I appreciate you all appearing today.
Your Honor, I'm sorry. I believe the defendant is here for this case.
Oh, where?
It's the phone number ending in 000.
User 000, Judge.
Oh, well, okay. Needed to know that. All right. So is it Cindy Jimenez? Can whoever is on the cell phone ending with the 3 zeros, please speak and turn on your camera if you can.
You know, I'm doing a call Zoom. I didn't know how to I tried to figure out how to do the Zoom thing, but it gave me the option of just calling. So that's what I'm doing. I'm not computer savvy. I'm past 60.
Ma'am, would you state your name, please?
Yes, Cindy Hemans from Von Fenwell's Elite German Shepherds, LLC.
Okay. Was she, ma'am, were you present for the previous hearing on July 13th?
No, Your Honor, I've been in and out of the hospital. I had back surgery and they fitted me for a brace and botched it and fractured my entire rest of my spine. I had to go back in for emergency surgery. When I came out, I was paralyzed. So I've been in and out of the hospital trying to walk. And then we had our kennel started on fire from an employee throwing a cigarette in there. So it's been a little bit hectic, plus COVID, and in a wheelchair.
My apologies, ma'am. What I need to inform you of is that you have been named as a party defendant in cause number 2022 DCV 0314, and a motion for default judgment was filed back in June. Based on the history of this case, there were some issues with service. At some point, I guess you have received notice. I'm not sure exactly how, but I need to find out. A hearing proceeded back on July 13th with some testimony in support of the default. I don't believe anyone appeared on your behalf. You're appearing here today. This was set in kind of an attempt to finalize the default. And so I need to know if you are intending to hire someone to represent you, or if you're going to proceed representing yourself. I don't know. Have you received the motion for default judgment?
No, I never received that, Your Honor, and I'm going to be defending myself. The whole issue of this trial was regarding the AKC papers for his dog. He has those papers already. The mother dog, her name was Olivia. She was bred in Bosnia, Serbia, and the father of the dog, Iraq from Mining, was in Serbia, and with Corona and all that other stuff and the AKC, it took time to get the papers, especially from Bosnia. So the dog has been registered, and he has everything that he needed, including I changed it from limited registration because he was just buying a pet, and I changed it to full, and normally we would charge $1,000 extra for that, and I paid the fee. It was just a matter of time, especially when you're dealing with Europe and with the Corona. Things take time, and he just wasn't being patient. Our contract guarantees that they will get the papers, and that has been satisfied. He really only just wanted a pet. I'm sure the dog is beautiful. Maybe he's thinking other things. I did give him the full rights to the dog to go show and breed and whatever he wanted to do. But it was very difficult getting in touch with them. Of course, Ramon stopped answering the phone, and even though I was keeping him abreast of it, and the attorney was impossible to get in touch with. And I'm in a wheelchair dealing with a crisis as it is.
Okay, Miss.
But they have everything that they needed.
Okay, Miss. I'm sorry, I apologize. Is it?
Hymans. Hymans.
Okay. Ma'am, what I would like to do at this point, in terms of the default hearing, Mr. Marquez, I think we need to kind of just put the brakes for a second. Do you have an email address, ma'am?
Yes, Elite, ELITE, GSD, so like German Shepherd Dog, at yahoo.com.
Okay. What I am going to do is I am going to ask Ms. Hernandez if you would please email her the original petition and the motion for default. Let me make sure. That's it. Yes. And the motion for default, if you would please email it to her. And I don't know, ma'am, have you been in contact with the court itself? So with Mr. Hernandez or anyone from the court?
I did call to see how I could get the Zoom thing going because I didn't know how to do it. So
Okay.
They told me how to do that.
So after this hearing, I'm going to ask you to call again so we can confirm all your contact information because I am going to reset this for at least 30 days. So it'll be 30 days. Did I already say a date? Had I already written it down? I don't see it.
No.
8/24.
We can't finish this up today.
I'm sorry?
We can't finish this up today.
Ma'am, I am first of all, having to review some of the information from the previous hearing. Ms.
Okay.
Wright, I am going to need the record on that July 13th hearing. And once we receive that, then we will provide a copy to you as well. So there are different specifics. It's not that simple in terms of wrapping it up today. I also want to check with you. This may take a little bit longer, Mr. Marquez. So I'm going to check with her in 30 days after she's received all of that information, if she intends to hire counsel or not. So we may not have a definitive decision on that 30 days. So we're going to do a status in 30, ma'am, hold on. We're going to do a status in 30 days. We'll get you the petition, the motion for default, and the transcript of the July 13th hearing.
Okay.
And then we'll go.
Your Honor, my business has pretty much gone out of business because the fire, it destroyed my thing and I didn't have insurance on it because of my back injury. I'm filing for disability in the process of that, and I'm probably going to be filing bankruptcy because I have no money and I can't walk.
I understand, ma'am. I'll tell you this, there are several things still kind of outstanding. What I want to ensure is that because you have appeared today, that you have all the information basically to get you up to speed on this case. Now, whether you know, you're financially able to hire counsel or want to proceed forward, or I at the very least, I need to make sure that you know everything that has happened up until this point. Okay?
I appreciate that.
And so the default will
Thank you.
remain pending, and I will provide you the information. We will reconvene in the same manner as we have today in 30 days. So that is going to be, oh my gosh. That's going to be September 28th.
Okay.
At 11 a.m.
That's El Paso time, correct?
That's correct. So it's Mountain Time. That will be a status, Mr. Marquez. Okay. All righty.
Yes, Your Honor.
Ma'am, if you would please call the court after we're done here on Zoom, so we can get all your information. And if you have any other questions, logistical questions anyways, in terms of our process, let you know. Okay.
Okay, and could you give me the phone number that I should be calling?
Sure, it's area code 915-546. The 2130? 2130? Yes,
ma'am.
Yeah.
And I should just give them my information so they can send me all of the documents and stuff regarding this case.
Correct. They'll be emailed to you. I will tell you with respect to the transcript, that will take a little bit of time, but it will be sent to you before the hearing.
Okay, that sounds great. Thank you for all of your help, Your Honor, and for listening.
Thank you very much. Mr. Marquez, we'll just go with the status in 30 days according. We'll just see where we are after that. Okay.
Yes, Your Honor. And I just want to clarify for the court that the motion for default judgment, when it was filed via the Odyssey e-filing system, that Ms. Hymans and Von Feinweld's Elite German Shepherds were a service contact on that at the email that she has just provided the court, elitegsd@yahoo.com.
And that was on what date?
The motion was filed on June 14th of 2022.
Understood. I hear you.
Thank
Okay.
you.
And
Thank you very much.
When did you send me that? When did he send me that? I get like over 500 emails, junk mails, and political stuff every day. It's insane. It doesn't
So,
matter if you unsubscribe.
The motion was filed on June 14th, ma'am.
Okay, and he says he sent something to me?
So there is the process, the way documents or pleadings are filed are done through this e-filing system. And within that system, Mr. Marquez has indicated that the email that you just provided was the email upon which that motion was delivered. And so if you go back in your emails, June 14th, 2022, I don't know if sometimes you have to look through junk mail, things like that.
Oh, yeah.
Should be some type of e-filing. In any event, the court is going to be emailing it to you directly. And you can see there that it is file stamped in June. So we're going to come back for a status in 30 days.
Okay, thank you very much for all of your help, really. And I know this is a confusing case.
No worries, ma'am. We'll see you in 30 days.
Okay, have a good day. Bye-bye.
Thank you, Mr. Marquez.
Thank you, Your Honor. May we be
Oh.
excused for today?
Yes, sir. Have a good day.